Good afternoon, everyone. Welcome to the Appellate Division First Department. This afternoon, we are so pleased to be sitting in Bronx County. We are here at the New York State Supreme Courthouse in Bronx County. As you know, the First Department consists of two boroughs. We have Manhattan, or two counties. We have New York County, and we have Bronx County, and we are delighted to be here with all of you this afternoon. I want to welcome a class of students, Mr. Basil Manolakis, who is here from Bronx School for Law, Government, and Justice, with about 21 juniors and seniors. Would you stand? We are so pleased that you are here. You may be seated. We are so pleased that you are here and are showing an interest in the law and in what we do as justices. And we certainly hope that you learn from the experience and that you don't see anything that you don't want to, that discourages you from continuing in this area, in this field. Our Justice Marsha Michael, is the founder of this program. And Justice Michael, and Justice Yanette Rosado are facilitators of the program. So I want to thank and congratulate them for their efforts and interest in bringing along Bronx students. Today we have more than 6 hours of argument time that has been requested, so I ask counsel to keep that in mind as I call the calendar, and remember that we have the briefs, we have the record, we're fully familiar with the facts of the cases, so please ask only for the time that you need to make your most important points. Understand also we have a series of lights here. When the red light goes off, your time for speaking is ended, but if we need to, we will continue to ask you questions. So you'll get to make all of your most important points. I'm going to call two cases. While I'll call them in order now, there are two cases that I'm going to call at the end of the calendar, right before 15 and 16. And they are number 2 on the calendar, which is Anderson Avenue versus Fuller, and number 12 on the calendar, which is People versus Asim Brown, as some of us are recused on different cases. So I'll just redo the calendar as necessary in that respect. Okay, People versus JT. Submitted. Anderson Avenue versus Fuller. And when I call the case, I want you to rise and tell me the amount of time that you would like for your argument. If both parties would rise at the same time, then I'll know that you're here. Okay, I'll give you 6 and 2 and 6. A children? Submitted. Roland versus Zevron Realty? Give you 5 and 2, 1 and 6. People versus Jason Valencia? 4, 1, and 4. Hernandez versus Port Authority of New York and New Jersey. Okay. PAI 5 and 3, um, plaintiff 5 and 1, W. Sajo 5 and 2, I'm not sure if I'm doing this in order, but I apologize. CSS 3 and 1, O'Kane 3 and 2, PB Vent 3 and 2, I think I have everyone. Did I get everyone there? Oh, CSS 3 and 1. Did I not say 3SS? Okay, all right. That's everyone. Great, thank you. State Farm versus Moving and Storage. 5 and 1, I don't believe there's a cross appeal here. So 5 and 1 and 4. People versus George Pagan. Submitted. Naomi R. versus Fabian R. Submitted. State of New York versus Joseph T. Okay, any questions? Okay, submitted, thank you. Mackenzie Moses versus Lil Kage. So you asked for, the appellant is 5 and 2, and you're the respondent, 5, is that right? 5, 2, and 5. People versus Asim Brown. Submitted. Tiburcio versus Grand Avenue. Submitted. Moore versus Wood. 5, 2, and 5. People versus John Appouzi. 4, 1, and 3. Auachcher versus Clark. 5 and 2 and 5 and 2. Okay. First case for argument is Anderson versus, I'm sorry, just so as a reminder, numbers 2 and 12 are going to be held to just right before Auachcher versus Clark. So the first case for argument is Roland versus Zevron Realty. Thank you.
Represent the appellant, Total New York. As your honors clearly know, this is a simple slip and fall matter whereby Total New York moved for summary judgment, trial level.
So how did you meet your burden here, where that you didn't negligently install the roof when you had you presented no expert testimony or anything else to indicate that the roof was properly installed?
Your Honor, I believe that, submit to the court that we made our burden of proof by 3 separate inspections. First, Mr. Martinez, who testified on behalf of the owner, Zevron, stated that he inspected it himself and found no issues at all with it. Secondly, Zevron hired an independent outside engineer, and that engineer inspected as well. We know that from the third inspection by the New York City Department of Buildings, which happened 6 months later, wherein they articulated in their findings
Didn't the owner call the company back to do repairs after that building inspection?
Submitted to the court, there was absolutely no proof at all by anybody that anybody called Oak New York back after September 2nd, 2017 to come and repair the roof or notify them that there were issues with the roof. The plaintiff repeatedly notified the supervisor in the building, repeatedly texted, and that is in the record on the.
But counsel, what do you make of the invoice from August 3rd of 2018?
That is exactly, Your Honor, if you look exactly at that invoice, I'll use some page references. The exact language is the same. What happened was it was invoiced and not paid. So it was just re-invoiced. And if you look at the.
And it doesn't make mention that it's a re-invoice, it just appears to be a new invoice.
The language is exactly the same, the amount is exactly the same.
Maybe it was exactly the same work done.
That would have meant that they did it twice, you know,
Be-
according to Mr. Singh, there was an issue with getting a bill paid. And the testimony, the invoicing, wasn't always matching up. So, and if you recall, with respect to the timing of the inspections, you could not have had a second roof put on within 6 months and not have another inspection. There's no other further inspection.
Counsel, what evidence is there to support your claim that the Department of Buildings inspected it and found it satisfactory? Is there a record reference to it that you can point me to? I have the briefs before me. What evidence, though? Is there a report from DOB saying that they went in and that it was good?
Yes, Your Honor, there is. In the record, there is a series of DOB findings. And that's.
Maybe when you get back up, you can tell me where in the record?
Of
'cause
course, I
tried to
will.
find
Yes,
it.
Your Honor, thank you. But that's where I also get the comment that the building inspector stated that the owner had hired independent separate counsel, separate engineers to inspect the roof after it was performed and finished in 2017. That's why I was addressing the other question with respect to this other, what I would submit to the court as a re-invoicing for the same exact language, the same exact cost.
Viewing the evidence in light most favorable to the non-moving party, wouldn't the plaintiff's deposition testimony alone establish an issue of fact as to whether a leaking condition was created in the roof?
Your Honor, with all due respect, no. The plaintiff's deposition specifically states, A, she had no idea where the leaking was coming from, but more importantly,
She knew it was coming from above,
it was above her door.
and she's on the last floor of an apartment building, which only leaves the roof.
Correct.
Okay.
She specifically stated she never knew that there was any work done. She had no idea who Total New York was, and she had notified Zevron and the supervising maintenance engineer in the building numerous times, which is proven in the record through texts. She never stated anything about Total New York, the work that was done. She never knew there was roofing done. She specifically stated that. And she specifically stated that on the day of the accident, when she first went out for the first appointment of the morning, there was.
You suggesting that a tenant has to know which vendor completes work in a building before that vendor can be held liable for work that has not been done adequately?
Well, Your Honor,
I know of no case that requires that, so please tell me.
the plaintiff does not have that, the plaintiff herself has not that burden, of course. The burden is that someone has to show that the roofing was done negligently. And nobody, and I mean nobody in this multi-volume appeal has demonstrated that it was ever done negligently. In fact, again, Mr. Martinez said he inspected it himself and he found it was good and he,
Is Mr. Martinez an expert? I thought he was a superintendent.
he is the superintendent of the building.
Okay, that does not make a roofing expert. So his observations as a person, it would be like me going up to the roof and saying, it looks fine to me.
In other words, Your Honor, if I may, the defendant would have a negative burden to prove that nothing was wrong, which isn't the burden of proof. And even under Espinal, the plaintiff still has to come up and show that some sort of harm was put into place. There was no proof whatsoever that after the Total New York did its job, they were ever called back for any sort of problems.
Okay, thank you. We'll have her-
Thank you, Your Honors.
Afternoon, Your Honors. Plaintiff's argument is relatively simplistic. The evidence based on the testimony of the parties is that the roof was leaking in 2016. The work was done
Sorry, I
in...
have to ask you, did you state your appearance? I think
Oh,
you
I'm
said
sorry.
Good afternoon, and then,
Good afternoon. John Grill for the plaintiff respondent, Your Honor. Thank you. Apologies. The simplistic argument of the plaintiff is that there's testimony and also video evidence that shows that the roof was leaking well prior to the roof work in 2016. The roof was repaired by Total in 2017. The roof continued to leak in 2018 in a similar manner as it had in 2016. That's shown by the testimony of the parties, and also there's video evidence.
What's the proof that they were informed, that they were notified that there was a problem with the work and called back? And please don't tell me this statement by your worker, I think so. We might have. That certainly doesn't satisfy your burden. So tell me where in the record there's an email, anything to document that they were called back.
There's only the testimony of Mr. Barberi, the property manager, to the effect that he had called Total to return to perform work on the roof.
and did they return?
That's the statement I have in the record, Your Honor.
That's enough?
Yeah,
That's enough? We called them, I don't know what day, I don't know who I talked to, I don't even remember what I said. And most astonishingly, I don't know what they said. And I don't know what happened after that phone call. We're supposed to rely on that, sir?
well, there is evidence, again, Your Honor, that it leaked before, it leaked after, and the property
I believe
manager
there's a
called.
leak.
What your evidence is that there was a leak before and there was a leak after, but you have no evidence to support anything but that you think there was a phone call. You don't know when they came back to do the repairs or anything beyond that. Is that what you have?
The plaintiff herself doesn't know any of those facts. I'm just saying what is in the record based on what the property manager said.
Okay,
So you're
thank-
proceeding under Espinal, right?
Well, I'm saying that the appellant has not met their burden of proving an absence of issues of fact by showing that they did not unleash a force of harm
Well,
or
there's
create.
that's what I'm getting to. So the first exception under Espinal would be you launch a force of harm. And that means there has to be an affirmative act. So necessarily, notice is irrelevant. If an actor, if a defendant creates a condition, notice would be irrelevant. Isn't that your better point?
Well, I'll adopt that point, Your Honor, but
Counsel, what are the issues of fact?
the issues of fact are whether or not Total failed to perform their roofing negligently, since it leaked just as bad after they did their work as it did before.
Based
Counsel,
on
are
Mr.
you-
Barberi saying that I think they came back?
I think he testified he, in fact, asked them to come back. Now, what that consisted of, I don't know. I would
So
have
you're
to...
the plaintiff here, and it's the landlord who was making all of these phone calls.
That's correct.
Okay, we'll hear from the landlord. Thank you.
Thank you, Your Honors.
Good afternoon, Your Honors. May it please the court, Sean Schatzel of Lewis Brisbois, appearing on behalf of the defendants, third-party plaintiffs, respondents.
So you heard a
Landlords.
lot of questions about what evidence do you have that
Sure.
the roof wasn't repaired properly in the first place? What do you have?
This case, I think, is an Espinal case. We're focused on the first factor, launching a force or instrument of harm, but it's really a case about summary judgment burden, okay? And the defendant here, Total New York, did not meet their burden to show that they did not create or exacerbate a leak condition in the roof. They just simply did not do that. Their arguments Their brief is focused on pointing to gaps
So
in the record.
they argued that they finished their work a year before, that your people did not call them back or notify them that there was a problem, and so they are not responsible. They have no relationship with the plaintiff.
And Your Honor, I think that evidence would be very helpful to them if this case was about notice. If they were the owner or they were the manager and they had to prove a lack of notice. This is an Espinal case, and I don't think notice is relevant to them. What we do know is that there was a leak.
Really?
Yes.
So a company can do work, and they're supposed to divine that there's a problem from thin air? How do they know I have to go back and fix a problem unless they're notified of the problem?
Well, I believe the question really, Your Honor.
No, the question is what I asked. Please don't restate my questions. Okay, so answer my question.
Okay.
Tell me, okay, how were they supposed to know that there was something wrong with the work that they did if there was no notice to them of it?
If they were not contacted, then they would have no way of knowing. Your Honor is 100% right.
Precisely. So tell me where in the record, other than this statement by Barberi, that I think somebody called them. That's what I read.
You're correct, Your Honor. You're correct.
How is I think? How does that meet the burden there?
Again, I think it's their burden to show affirmatively that they did not create or exacerbate a dangerous condition, and they failed to do so. But if Your Honor is asking me if there's proof in the record showing definitively that the plaintiff or the property owner contacted them and said, hey, there's an issue, I need you to come back, if there's definitive proof of that, it does not exist.
Counsel, is it accurate that the 2018 invoice is a duplicate for work that was previously done, or is that in relation to new work?
That's not clear, Your Honor. So counsel's right that they do look the same, but there are different dates on them, and as far as I know from reading the deposition testimony, no one clarified that point. So for all we know, that could be for subsequent work. And there was some testimony from Mr. Singh, the CEO of Total, when he was asked about, were you told about any leaks after the fact, any problems after the fact? I don't know. And yes, then we have the testimony from the property manager that he may have called them back. So that subsequent invoice may be related to subsequent work, but there frankly is no proof in the record definitively showing that's the case. A few other points I'd like to make. To the extent notice is relevant, and I do not believe it is, they point only to gaps in proof. And on top of that, there is evidence in the record of a leak from plaintiff's testimony, that this was ongoing for years, that it was ongoing prior to the accident. And I think more importantly, there is precedent from this court talking about the 1-year gap. Okay, they focus heavily on the 1-year gap. They completed their work, and this happened over a year later. There is a decision from this court cited in our brief, Godbane, on page 20. Okay, that is an Espinal case. That is a case involving launching a force or instrument of harm. It involved a plaintiff who fell on defective steps in a 7-Eleven that was undergoing renovation. Okay, if Your Honor take a look at that case, particularly the trial court's decision and the facts of that case, that contractor ceased its work about a year before the accident, okay? And it made the same argument they're making here. It happened about a year beforehand, we can't be held liable. And this court said in that case that there were questions of fact about whether they launched a force or instrument of harm, okay? And I think that's significant, and I ask Your Honor to take a look at that case. The other point they make an argument in their brief under some of the Espinal precedent from this court talking about, and I think Your Honor may have mentioned it, affirmative acts of negligence, creating something, versus omission, right? And they cite case law talking about whether the contractor's work rendered the condition less safe. That argument is raised for the first time on appeal. They did not raise that argument below. I'd point Your Honors to 176 to 181 of the record. I'd also point you to their reply brief. They do not make that point, and nor does that argument qualify for the exception for arguments raised for the first time appeal. Question of law, when it couldn't have been ignored below, hadn't been raised, face of the record, that sort of thing. If they had raised that point below, I don't know, plaintiff perhaps could have submitted an affidavit stating that, by 2018, after the work was complete, the leak became more frequent or more voluminous. And plaintiff did not have an opportunity to do that because Total never raised that less safe argument before the Supreme Court. And the Supreme Court had no opportunity to rule on that argument. And in any event, even if this court were to consider that argument for the first time on appeal, they failed to meet their burden because it is their burden. Can I finish?
Finish your sentence.
Okay. It is their burden to show they did not create or exacerbate a dangerous condition. And we know that their job included waterproofing the entire roof, the whole thing, brand new roof. And they provided no evidence whatsoever as to whether that leak was better, worse, something else. They instead tried to argue that there was no leak, they had no notice of any leak, and all that. And I respectfully submit to this court they failed to meet their burden, and for that reason, this court should affirm the relevant portion of the lower court's order.
Thank you.
Thank you.
Again, Your Honors, thank you for the opportunity. In response to Justice Rosado's request, and thank you for the time, pages 1176, 1177, and if the court will note, there's also one on 1174. They're the same letter of completion by the New York City Department of Buildings, and it states that, it addressed to various people, but it states that the work related to the above application is completed, was signed off by the Building Information System in February 2018, and I'll get to a moment if I have Justice Michael's question about the earlier invoice. And it says, because the job was professionally certified, the owner retained a registered professional engineer or registered architect who certified that the contents of the application comply with the applicable laws, rules, and regulations of the Department of Buildings. Because this job was filed as a Directive 14 of 1975, the owner retained a registered professional engineer or registered architect who certified that he or she inspected the work approved on this application and that it complies with the applicable laws, rules, and regulations. Based on the nature of the work filed in the application, a new certificate of occupancy is not necessary. So that's the Department of Buildings clue that the engineer, a private engineer. I also wanted to point out very quickly to Justice Michaels that the question of the timing. So this was, these are March 22nd, but it talks about it was completed on February 6th, 2018. So in other words, the invoice of 6 months later would literally make no sense, right? If the work had been done after this, you'd have a whole new formal process by which the Department of Buildings, and these would demands and searches made from the City of New York. So there's no further documentation from the City of New York to demonstrate that there was anything further done. Thank you, Your Honors. Thank you very much for your time.
Thank you both. I have a clock here that's not really listening, following what I'm doing, so forgive me if there's an issue. No, I didn't. Yeah, that's right. Let me just do it. People versus Jason Valencia. Okay, that should stop it. That resets it. Right, exactly. Question is how to change that. Just a moment. I don't want this. No. Stop. I reset. So as we don't, not to delay further, we are just going to begin, and I'll just leave it at this. Just give me a minute. Okay, I'm going to go like that, reset. It's okay. Our clock at the Appellate Division on 25th Street works a little bit more consistently, so forgive me.
Just let it
It's
go.
okay. I'll figure it out. We gotta get going. No. Unless turning it off.
It might help.
Great.
Good afternoon, Your Honors, and may it please the Court, Phoenix Rice Johnson on behalf of Mr. Jason Valencia Martinez. I would like to use my time today to address the first point in my briefing with respect to the excessiveness of Mr. Martinez's sentence. Mr. Martinez is, by all accounts, a hardworking individual with zero criminal contact prior to this offense. He had never even been so much as arrested.
But he doesn't apply for a gun license. The entire, New York State structure with regard to Bruin wasn't dismantled. Doesn't he have to apply for the license before he can challenge not receiving a license?
In this case, Your Honor, with respect to the excessiveness of his sentence, there's no question that he obtained the gun illegally. He admitted to that when he was interviewed by officers at the precinct, and it's true that gun violence is very serious.
Okay, counsel, so let's talk about the excessiveness of the sentence. This started as a felony, right?
Correct.
And he was afforded an opportunity to plead to a misdemeanor.
Yes.
And he received a misdemeanor probation
Correct.
of 3 years.
That's correct, Your Honor.
And what exactly is excessive about that?
In this case, the conduct was so aberrational. Mr. Martinez was a convenience store manager, a bodega manager. And earlier on the day of the offense, a neighborhood woman had said that a dangerous man was planning to attack him. He went to the store's basement and got a gun that was stored there.
So we know the facts. He's worried that someone is going to, in the neighborhood, is going to attack him. So he runs downstairs and he gets this illegal weapon. And as he's coming up, he is attacked by that very person. He gets injured in some way. Either he's shot, there's blood. So he calls the police at that time, says, yes, that's the gun on the car, or wherever it is. It's illegal. And I guess what your argument is that because he called the police rather than waiting to be found or whatever it is, he should get more than the reduction from a felony to a misdemeanor and more than simply the 3 years probation or the.
That's correct,
3
the
years.
3 years,
Yeah.
yes. I want to
You're
point out,
saying he should get the 2 years, the minimum?
yes.
2 years.
Here we're
So the 1 year should
requesting
be off.
time served. He has served 2 years and 3 months. Mr. Martinez is a very hardworking person.
Counsel, but didn't the court take that into consideration with the PPI? How much he worked, his strong work ethics? Didn't they take all this into account in formulating this misdemeanor with 3 years probation?
I believe the court did, Your Honor, but I'd like to point out here that Mr. Martinez has consistently had professional.
Had he been convicted of the felony and this matter remained a felony, what was his sentence exposure?
He was facing up to 15 years. And here, he is determined to get a commercial driver's license so that he can make large-scale deliveries. But the terms of his probation make that difficult. He can be subject to curfew, he's limited in where he can visit, and this is someone who's already served the vast majority of his probationary term.
And when is the remainder of that term ended if we don't reduce? When would that be?
I believe it would be December of this year, Your Honor. And Mr. Martinez.
So in less than a year then?
That's correct. But for someone who is working class like Mr. Martinez, who comes from an immigrant family, is trying to support his family, that is a long time to be limited in his ability to pursue his ultimate career ambitions. There's no doubt that gun ownership is serious, but here it was due to such aberrational events that led to this offense. I mean, Mr. Martinez is just a law-abiding individual. From the time he arrived in this country onward, he has demonstrated that.
Thank you. You have some rebuttal.
Good afternoon, Maria Wager for Respondent, the Bronx District Attorney. The people have
So
no...
why he's gotten through more than 2 years of probation. The minimum is 2 years. Why isn't he entitled to the 2 years, given the circumstances here?
Because, Your Honor, for him to take this plea, it was with the agreement of the Bronx DA's office, where he was charged with a C violent felony offense that carried up to a maximum of 15 years in prison. And because of this very mitigation stated to this court, that was the basis for this office to agree, along with the court, to come from a C
So you're
violent felony
saying he got the
offense.
benefit of his bargain. He negotiated for this. He got a reduced plea from a felony to a misdemeanor, and no time in jail. He got the 3 years. He got the benefit of his bargain. What about the additional information she's giving, the counsel is giving now, that he needs to be employed? It would accelerate his employment, given his financial circumstances. I think that's the argument.
I don't believe that is new information, additional information. That was in the pre-pleading memorandum, as well as as the brief to this court. I don't believe it's new. If it is, it wasn't brought before the sentencing court or
So
the...
you're saying all information, even what we've heard today, has been taken into consideration already?
It has, and it was the basis for this very generous, lenient plea offer that was a quid pro quo. The people came down from a C
Counsel,
violent felony offense.
the appellate division's review of excessive sentence, we don't have to determine that anything was done incorrect at the trial level. We can review it anew, correct?
You can, yes,
And we
correct.
can look at the facts that are before us and make a determination independent of what was done at the trial court level, correct?
Absolutely, Your Honor. What the people are arguing, however, is that your extraordinary interest of justice review power is not warranted here. When he got a very generous plea offer, that he should be held to his part of the bargain. He has 8 months left on probation to be charged with a C violent felony offense and to get an A misdemeanor for these very reasons. There's no reason now he should renege on his part of the bargain, notwithstanding this court's power to modify a sentence. I just want to point out also that defense asked for 1 year. That's illegal. It has to be 2 or 3, and he has 8 months left on that sentence. If this court has any questions about the Bruin claim, I'd be happy to address them. Otherwise, we'll rest on our brief.
Thank you.
Thank you.
We concede that the request for 1 year was an error. I apologize. We're asking for time served or 2 years. Wanted to mention as well that if an individual is likely to recidivate on probation, research indicates that that is likely to happen in the first 6 months to a year, and there has been no indication of such here. And as your honors are well aware, you have independent discretion to look at this complete record, this kind of extraordinary set of circumstances that led to the offense, and recognize that Mr. Martinez wants to return to a life where he can work to better himself and better his circumstances for his family and continue to provide and to be a productive member of society. There's every reason to believe that he will return to doing just that if you reduce his sentence to time served. Thank you very much.
Thank you. Thank you both.
That's annoying.
Hernandez versus Port Authority of New York.
Anything else?
So not everyone needs to, are there enough chairs here at the table? You have, okay. There are only 2 chairs there. You can bring one over here. Thank you. When you rise, you have to tell me who you are and remind me of the time, okay? I have all of the time, but I won't know who's who.
Okay, good afternoon, Your Honors. I am Richard Ashnault. I represent defendant, second, third-party plaintiff, appellant, respondent, Precision Air, and I have, I believe it was 5 and 3.
5 and 3, you do.
Okay, I'd like to start by dealing with the indemnity issues here, and for the court's edification and the parties as well, I provided 2 additional cases that everybody has copies of, and I'd like to talk about those a little bit in terms of, first in terms of the indemnity argument. Both of those cases, Sternkopf and DeGidio, involved a plaintiff who was injured during construction, obviously. The employer was the party at issue here. Precision is not the employer. We were the HVAC subcontractor. PB Ventilating was the plaintiff's employer, who was a subcontractor of Precision Airs. So it's kind of a step removed on these cases, but the reasoning is the same. So in Sternkopf, you have a sprinkler head relocating.
It's your position that you shouldn't have to indemnify.
That's correct.
Right. But don't we have to look to the contract here?
Yes, and
where
the contract here.
Seems to indicate, the contractual clause indicates that you're responsible for the work arising out of or resulting from the performance or non-performance of your work.
That's correct.
So wasn't this triggered by the work that you were responsible for?
No, Your Honor, it was not. It was not.
But you received the contract from Sajo, I believe, and you subcontracted to PB Vent.
Correct.
So you were responsible for all of that work.
We were responsible for the HVAC work, yes.
Yes, but you were also responsible for the PB Vent. That's why you subcontracted it.
Correct. The argument here, Your Honor, is not that the argument here is that the injury-producing work had nothing to do with the HVAC work that Precision Air or PB Vent was doing.
Well, that's if you take a very narrow look at what was happening. So you're essentially alleging that because he was moving the dolly at the time, that was outside of the work that was being done?
Well, the dolly and the responsibility to protect anybody from any danger that arises from the dolly had nothing to do with the HVAC work. That's
Well, to
where
be
the Sternkopf
clear,
and DeGidio cases
to be
come in.
clear, he was moving the dolly to continue with the work that you were responsible to have happen, right?
He was moving an obstruction that was in the way of the work. So this was a defective condition that was in his way that he was trying to
So how do
remove.
you divorce the obstruction from the work that was being done?
Again, I'm going to point back to the Sternkopf case where you have somebody.
Well, we have a slew of cases in this department that don't so narrowly parse out actions in this way, right? We have held that on your way to your job site, if something happens, even that could fall under labor law. So the fact that moving the dolly was not a part of his HVAC work is of no moment.
I would
No
disagree
moment.
based on the Sternkopf case, Your Honor, where you have somebody
You
tripping over a
cannot
piece-
hang your hat just on that case because we have thousands of cases, okay? Thousands of them. And we have plenty of cases that, as I've said, have held liability on acts that were not part of the actual job they were there to do.
Why don't you finish your argument about Sternkopf and then move on to the other?
Okay, well, yeah, this is with respect, first of all, to the indemnity argument.
Yes.
As opposed to the labor law.
Yes, we understand that.
Okay, so with the
I mean,
indemnity
that's why I
argument.
started off with reading you what the contractual information, what the.
Right.
Okay, so that's
Right.
what we have to look at.
Right.
And as has been said, you have a rather narrow view of it. you refer to the case. We've said there are many cases. If you want to, finish that point.
Okay, so again, Sternkopf, you have a gentleman who is relocating sprinkler heads, is walking to do his work, and he trips over a piece of carpet that is discarded in the hallway. This court held that had nothing to do with the performance of his work and dismissed the
And maybe it
contractual
didn't. That's a very different fact pattern than we have here.
Okay,
So-
is that because? the
I'm not
plaintiff here-
answering your question,
Sorry.
but it's a very different fact pattern than the cases here. I mean, you're talking about a piece of carpet that has nothing to do with his work. I'll give you 1 minute to get to your other issue, which is, I think, an important one, your labor law issue.
Okay, well, just like the piece of carpet, the dolly that was full of masonite here that had nothing to do with the HVAC work was an impediment to this. It was a trap that this plaintiff succumbed to, so to speak. And if he had not tried to push it out of the way, would we be having the same argument if it tipped over on him without him moving it?
You're asking yourself the question, so you should answer it, because you don't get to ask us questions.
I submit that no, we would not. It's not. It's the same situation, because it is a danger. It is a defect that was not of his making and had nothing to do with his work.
Say
So you're not-
for it was, go ahead.
No, you go.
Say for it was a barrier to him completing the task that he had been assigned.
Well, the carpet was a barrier to his walking to the plaintiff in Sternkopf walking down the hallway.
We don't know if that plaintiff saw that carpet. In this scenario, he's trying to do his work, he's doing the work, the dolly prevents him from doing the work, so he tries to move the dolly to continue to do the work.
Okay, correct, I understand, but I would argue, Your Honor, that at no time was either Precision or PB Vent, they were not delegated any responsibility to protect against any danger that dolly or the masonite presented to the
Thank
plaintiff
you.
here.
You have 3 minutes on rebuttal.
Thank you.
May it please the court, Glenn Kaminska. I have 3 and 1, Your Honor.
You represent,
Okay.
thank you.
Your Honor, Masonite. You're going to hear Masonite from different people here. O'Kane owned Masonite, and that's all.
No,
It
that's
did not
all.
do anything
That's
else.
not all. The masonite was on the dolly.
The Masonite was on the dolly, absolutely.
The
And-
dolly
and there
was, as you've heard already, right where the plaintiff had to work. He pushed the dolly fell with all of the masonite on it.
I agree, and none of that had anything to do with the Masonite. Plaintiff's own experts
It has to
said-
do with who the masonite belongs to, who's responsible for the masonite.
And you shouldn't
Yes,
put
but if we-
masonite on a dolly that's broken, especially since the masonite, the 30 sheets of it weighed 1,200 pounds.
And there's no proof that O'Kane put that on. As a matter of fact, the evidence really kind of shows that Sajo at 2 o'clock in the morning was using the Masonite. And there's more,
That
basically.
sounds like issues of fact.
Basically, there's issues of fact. And the fact that the court granted summary judgment to Sajo on contractual indemnity was absolutely wrong, when Sajo could be 100% at fault with this, where it might not even be our Masonite. For the purposes of this argument, I'll assume it is O'Kane's
I mean, there
Masonite.
was no evidence in the record of any other masonite.
Well,
Counsel, come
I
on.
beg to differ on that, but
There
it
is
doesn't
other
matter for the
Masonite
purpose
in
of
the
my
record,
argument.
counsel?
What it matters is that
he's just bringing
Sajo
that up.
used the Masonite, and that's not our fault. We didn't direct and control the guy's work. We didn't direct and control the area. So we were properly found not to be a labor law defendant, but as to the contractual indemnity side, there is at least an issue of fact. They can't even get.
I don't see how you're not a labor law defendant under the circumstances, but
Well, I look at, it's funny, counsel brought that Sternkopf case, and I don't think it applies to him because he's in that chain of the employer and such. I'm not in that chain. I didn't do
no, you're
that.
not in that
But
chain, but
merely-
your products, I won't repeat myself.
No, I understand. You're saying merely the Masonite merely being there, and I said.
Not merely
No, no, no,
being
no, no.
there.
Someone
It's like-
picked up
may
that
I finish?
masonite and
It's
put
like
it
a
in the dolly.
huge truck in the middle of the workplace. That's what that mason light was. given that it was right over the path that the work
And I
had to
don't
be done.
disagree. And plaintiff's expert at 1710 through 1714 will tell you that masonite was properly there. It was the proper device for the masonite. And again, I beg the court to look at the record to say, look at
We've
this
looked
2
at
a.m.
it pretty carefully, and I think my
say-
colleague already mentioned that
and I
it's
would
hard.
say
If I
Sajo.
might, don't speak over me, okay?
I would say Sajo would.
Don't speak over me, okay?
I apologize. Your
Thank you. So just wait till I finish my point. I think my colleague has already indicated that you're saying that it was properly put on that dolly, and it's hard to believe that one would put masonite on a dolly that was in the condition that this one was, totally battered wheels, et cetera, that couldn't be moved. Thank you very much.
Thank you. I'll address that on the reply.
May it please the court, Ralph Cosentino from Conway Farrell. I'm here for the respondent appellant CSS, and I have 3 in 1. It's our contention that the common law claims against CSS should have been dismissed on the basic espional practice that there was no duty between CSS and the plaintiff.
Counsel, you guys were gone from this job well before this accident, right?
That's correct. My client was involved with the build-out by the landlord, not with the build-out for the tenant space that was taken over by Apple.
And you're involved here because the dolly had your initials on it?
Unfortunately, the dolly had CSS on it. That's correct.
Okay.
But as you mentioned,
Should you be responsible, since the dolly with your initials on it are in the middle of this space?
well, it's, you know, the possession of the dolly was taken over by
That was sort of
Sajo
a
at the
friendly
time of the
question. Did
accident.
you have evidence? Did you have people, or any witnesses who testified that the dolly, they didn't put the dolly there, it shouldn't have been there?
No, there's nothing that really, other than the CSS, that connects my client's work with what was happening on the date of the accident, or putting the dolly from in the center of the floor that was interfering with the ventilation.
Wasn't
I
there
believe that you had a
complaints that-
superintendent that said that he did not even know who CSS was, and the O'Kane foreman testified that he never spoke to any of his or Sajo's employees to determine how the CSS dolly came to be used
That
for
is correct.
transport.
It's
Isn't that
712 in
right?
the
Isn't that
record.
in your favor?
That is in my favor.
Okay, I was waiting for you to say it.
Wasn't there evidence that CSS, while on the job, complained that other trades were stealing or borrowing without permission CSS equipment?
That's correct. And structured tone verified that that was a complaint that was made by CSS, and it was something that happened on this project.
Now, is there anything in the record that tells us when CSS left the job that they attempted an accounting of the equipment they had on the job in order to assess whether there was missing equipment that was being left behind and could not be found?
Well, the payroll records show that the last date work was done was March 8th of 2016, and this accident occurred on April 4th of 2016. There's no mention of where, you know, an accounting of the dollies, but structured tone and CSS both said that when they vacated the space, lock, stock, and barrel, they took all the equipment and everything with them out of the Apple space.
Apparently not.
Well, I mean, it is
Anything else?
possible that with the theft, that the dolly was taken and brought into and incorporated within the work that was being performed by Sajo on the Apple build-out. I otherwise maintain that we were properly, the labor law claims were properly dismissed against CSS, and that, you know, the contractual indemnification cross claims weren't dismissed, but there were no real arguments in favor of keeping them in play in the underlying motion papers.
Thank you.
Your Honor, excuse me, I represent Sajo. I believe I have 5 and 2.
Yes, but you have to tell me your name as well.
May it please the court, Alexander Cogbill on behalf of Sajo and the owners.
Thank you.
Given Your Honor's understanding of the facts and the indemnity issues, I'd like to start with the threshold question of whether the plaintiff injured in this case is entitled to the extraordinary protections of the labor law, and if so, whether he was the sole proximate cause of his own injury.
I can't even believe that you say that statement. We've got a dolly with a broken wheel and a nail in it. He testifies that when he tries to push it, it gets stuck and falls on top of him. So that even the most generous of arguments that he didn't handle it right, he didn't pull it with both arms, whatever, that would still just be a contributory kind of concept, not a sole proximate cause concept. You can't with this dolly. You can't.
Answer the question.
Okay, so the specific regulation at issue here, 28C, requires that the wheels of the dolly be freewheeling. And we have two objective instances in the record addressing whether the dolly wheels are freewheeling. One is by the superintendent, Bob Collins, following the accident, who was able to spin the wheels and they
But didn't he concede that he was able to spin the wheels when the dolly was turned over on its side?
So I'm pointing to the aspects of the record that we have, and
Right, but for wheels, for a dolly to work, it doesn't matter whether the wheels can spin when there's no weight on it. The question is, can those wheels spin when it's standing upright on its wheels, right? Let's start with that. Forget the weight. Just can it function? And there's nothing in the record, nothing that says that it was tested after the accident and that the dolly could work.
So we've all seen the photographs. So start with the photographs because one has a nail in it, one is completely ripped down the center. So these are not wheels, even if they can spin. Think of a car, the wheel might be able to spin when there's no pressure on it, but if it's completely flat and ripped up, it's not going anywhere. So that's the perspective here. If you move on to the next point, we know that you believe the wheels can spin and so that they could. But that didn't mean it was moving. So the next point.
if Your Honor would indulge just the second aspect of the record that addresses this, plaintiff himself, before the accident, was able to move the dolly. There was no
2 feet,
noise.
I believe, 2 feet, and it not even, and it abruptly stopped, and that's when it fell over.
The significance of those 2 feet is that necessitates multiple revolutions of the wheel without any noise, without any bumps.
But what does
without
that
any-
matter?
Said that? What expert report said that? That there were X number of revolutions of the wheel, et cetera. I don't remember reading anything about that. So tell me where that is in the record.
That's just based on the dimension.
No, oh, no.
So that's not in the record.
It's not in
So
So don't, if it's not in the record, and if it wasn't from an expert, then move on to your next.
Let's talk about the experts then. We have.
You can talk about whatever you like, it's your argument, but you only have 1 minute and 39 seconds left.
I appreciate that. Thank you. And thanks for the questions. We have experts on both sides here. One expert saying that this was the sole proximate cause, that the wheels did not play a role, looking at the photos, looking at the evidence in the record, and we have plaintiff's experts on the other side saying the opposite. I believe, Your Honors.
Where's the evidence in the record that he was directed not to move a dolly? Because under Gallagher, sole proximate cause isn't common law sole proximate cause, it's a 4-element test, right? And one of those elements is they have to disobey a directive or an express requirement that they forestall from engaging in a certain type of conduct.
So if the case gets to that point, I believe there is an issue of fact. The plaintiff himself testified that he knew that he did not have authority to move the dolly.
The plaintiff testified that he knew he didn't have it. Nobody came over and said, you can move the dolly, but he also said that no one ever said that he couldn't, and 2 people who worked with him said, yes, we were able to move things, items that were in our way of our work.
So I believe that those 2 questions strike at slightly different sides of the issue here. On one hand, there are post hoc ratifications by the supervisor that wasn't on the site that say, yes, he could have moved it.
His coworker and a foreman.
Correct.
Who would have been responsible for supervising.
Correct. But there's no testimony in the record as to an affirmative permission, or for that matter, a prohibition of moving the dolly.
So we have a failure of evidence with respect to one of the elements of Gallagher.
Exactly.
As to sole proximate cause.
Right.
So I see that my time has expired. Ought I address this on rebuttal, or do I have
I think
more?
you should.
Okay, thank you so much.
There's one more.
Good afternoon.
We have one more appellant. Are you an appellant?
Forgive me.
Yes.
Thank you, Your Honors.
Your appearance and who you represent.
Thank you, Your Honors. Adenaid Medina from Barker, Patterson, and Nichols. I represent PB Ventilating.
You have 3 and 2.
Thank you. Your Honors, I believe the issues as to my client are fairly simple. We have a contractual indemnification clause in the contract between PAI and PB Ventilating that requires a finding of negligence before the obligation to indemnify is triggered. Here we have no negligence on the part of PB Ventilating. First of all, the dolly in question was not owned by PB Ventilating. It was not maintained by PB Ventilating. The issue as to the floor protection was not owned, addressed, maintained, or created by PB Ventilating. PB Ventilating was not in charge of site safety or maintenance at the site. Nothing in the record indicates that PB Ventilating was negligent in any way in causing the accident at issue here. The contractual indemnification clause requires a finding of negligent or wrongful act on the part of PB Ventilating, and none of that is able to be found in the record here. And therefore, the contractual indemnification clause has not been triggered, and therefore, any claims of contractual indemnification against PB Ventilating should have been dismissed, particularly Precision Air's claim. And I would just point out that Precision Air conceded that PB Ventilating was not responsible for either site safety or the safety of the dolly, negating any potential finding of negligence by PB Ventilating. With respect to Sejo, Sejo is not a named beneficiary in the contract with PB Ventilating. The contract provides for indemnity for Precision as well as the owner. Sejo is not named in the contract, and therefore there is no claim, a contractual claim that Sejo can maintain. And as to the owners, as we argued in our brief, I do not want to belabor the point, but the owners never asserted a claim against PB Ventilating. Nowhere in the record is there any indication that they brought a claim, a cross-claim, third-party claim. They simply did not avail themselves of that opportunity, and therefore they cannot maintain any claim as to my client. If the court has no further questions, I rely on my brief.
Thank you. Thank you.
Thank you.
Good afternoon, Your Honors. Bill Cafaro for the plaintiff. In light of the court's demonstrated familiarity.
You represent?
Oh, I represent the plaintiff.
Thank
I'm
you.
sorry, I thought I said that. In light of the court's demonstrated familiarity with the record, I don't think I need to say anything, so I'm just going to answer whatever questions you have.
Well, I think we've asked a lot of questions already, so if you don't have anything you want to let us know, I think we're good. Thank you very much.
Okay, a couple of issues to raise in my rebuttal. One of the things that I wanted to bring up that I didn't get to before, the court below found that there are, and I'm quoting, there are triable issues of fact as to whether plaintiff's accident arose out of work performed by Sejo, O'Kane, or Precision workers. That's at the record at page 25. The fact that the court found that there are questions of fact as to whether or not this accident arose out of the work, Precision's work, it forecloses any finding as a matter of law that the indemnity clause was triggered, which requires that it arise out of the performance of Precision's work. So you can't have a question of fact on the one hand and a finding as a matter of law on the other hand with respect to the same exact language. So I would submit that the finding of the question of fact forecloses any possibility of finding as a matter of law that the indemnity clause was triggered. I would also like to talk about PB Vent's indemnity obligation. The language of the indemnification clause in that contract is at page 549 of the record, and that calls for indemnity for claims resulting from injury and or death arising out of any negligent or wrongful act, error, omission, breach of any statute, code, or rule, or breach of contract. Negligence is in the disjunctive there. There is negligent or wrongful act, or error, or omission, or breach of statute. So the fact that this is in the disjunctive means that it does not require a finding of negligence as to any of those. It can arise out of any error or omission during the performance of PV Vent's work. And if the plaintiff is to be faulted in any way for moving this cart out of his way, as would give rise to liability as against Precision, certainly that act or omission should also give rise to liability on the indemnity clause in favor of Precision and against PV Vent. Any other questions for anybody?
Thank you.
Thank you.
Your Honor, O'Kane again. Honestly, I don't have much by way of rebuttal here today. I will point out.
We're not forcing you to get up to argue, so.
I know, but after 3 consecutive arguments before Justice Manzanet, I figure I have to, out of respect, just get up one more time.
Up to you again.
I want to point out simply that before moving the dolly, the plaintiff inspected the wheels visually and physically to know that they were working and not broken.
Except, counsel, we talked about this before. There was 1,200 pounds of masonite. So there was no way he could really inspect these wheels. There was no way. He didn't know what was happening underneath, right?
And yet he testified that he did.
And that's your argument.
And so masonite sitting on a dolly does not create liability for O'Kane. It doesn't launch the instrument of harm.
I don't know that the dolly is the safety device here. The absence of the device would be braces or straps. Wasn't the masonite objects, given their weight and their height from the ground, objects that required securing? Certainly securing them wouldn't have been antithetical to the work that was being done in that moment. So the cart, in my view, really just furnished the occasion. It was the fact that masonite wasn't secured that allowed it to fall.
The masonite didn't fall over until the cart fell over. The cart was perfectly fine standing right where it was at.
Counsel, so the dolly is,
The masonite didn't move it, I'm sorry.
the dolly is a safe mechanism for masonite?
Yes, plaintiff's own expert says that the dolly was an appropriate device, 1710 to 1714 of the record. Plaintiff says it's a good device for it. It is the appropriate device for it. It is how you move masonite around a construction
As
site.
long as the wheels work.
With a defective, broken tire.
If the wheels work, certainly, but I'm not in
I
charge
know,
of the
they
wheels.
spun very well.
On its side, yeah.
Counsel for CSS again. No one said anything in their arguments about my client, but I'm here in case you have any additional questions.
Thank you.
Well, again, I believe 2 minutes.
You have 2 minutes.
I'd like to discuss briefly all of these parties that are saying that the accident did not arise out of the work that they were doing. Here, you're looking at the party that contracted the work, the party that supplied the masonite, and the party that supplied the cart. Those all sound under the broad definition of arise under from this court. That clearly applies to all 3 of them in our view. If there are no further questions.
Thank you.
Thank you.
Thank you all. I'm sorry, I'm leaving you out. Go ahead.
Just very briefly, Your Honors, I just want to point to the case cited in my brief at page 18, 242, 44 East 77th Street. The interpretation that Precision submits of the contractual indemnification clause suggesting that negligence should, the term negligent or negligence should be used sort of in a vacuum is incorrect. The indemnification provision clearly requires some kind of negligence or fault on the part of PV ventilating, and there is no evidence here of that. Thank you.
Thank you. I think we have everyone now. Thank you very much. Thank you all. I'm going to call the case so you can take places. We'll wait till everybody clears out before we start argument. State Farm versus Moving and Storage. Thank you.
Thank you, Your Honor. Good afternoon, Your Honors. Jason Levine for the plaintiff appellant. We submit that the defendant's submission of the evidence in support of their motion for summary judgment raised issues of fact as to whether Selective, at the time the release was executed, knew or possessed information which reasonably pursued would have given it knowledge of State Farm subrogation rights.
So there's no question that you didn't provide actual notice, and that's not your position at all. But you spoke with your clients, K and B, and they spoke with Selective. Selective negotiated with them. They told Selective that they had been paid by State Farm, and you feel that that is, I might have missed a fact. If I have, you will tell me. But you believe that that is sufficient for constructive notice.
That's correct, Judge Renwick, and it's the critical evidence here is that testimony from Mr. Balde, as you point out, the K&B's owner, which the Supreme Court in its decision didn't address some of the other evidence, but that's the critical evidence here is that testimony, which even it did give them actual notice of State Farm subrogation claim. You know, his testimony, Balde, that he told Selective that, quote, State Farm paid me for part, and then when his daughter called Selective, they told her they would pay her approximately $90,000 for the balance of the claim. That right there we submit on summary judgment raises an issue of
Didn't
fact.
she also say that they told her that she had to get the rest from the other insurance?
Right, that testimony from Mr. Balde was that when he spoke with State Farm, his insurer, they would have to give, because they paid the balance, they paid about $200,000 and change. Anything else would have to be recovered from M&S's insurance carrier. Again, so we would submit in view of that testimony as well as some of the other evidence, the court heard in granting summary judgment that there were issues of fact. Unless the court has any other questions, we'll reserve my time for rebuttal.
Okay, thank you.
Thank you.
Good afternoon. May it please the court, Dan O'Neill, Androvic, and Platic for the defendant responded. Your Honor, I believe that this is a situation where essentially State Farm is asking that Selective do its job. State Farm failed to notify.
No, I think what it is, so there can be actual notice or constructive notice. So we're talking about constructive notice. No one is saying that Selective got a letter from State Farm saying, we represent XYZ. What they're saying is between the investigator who was part of the scene of the fire, along with Selective's person, and all of the conversations that were had with their clients and their clients had with Selective, that Selective at that point had constructive notice, and where an insurance carrier has constructive notice that there's a subrogate, that they're not permitted to ignore that.
Your Honor, respectfully, I do not believe that Selective had constructive notice, that the mere fact that there were investigators at a common inspection of a fire scene does not establish that there was communication or that Selective's investigators should have inferred that State Farm had subrogation rights.
What about the fact that the clients actually spoke with Selective and indicated they had been paid by State Farm? Isn't that clear?
No.
To Selective at that point that State Farm was involved?
Well, that they were involved, but there's no evidence
that they were involved. Why is an insurance carrier involved in a case where they pay their clients?
Well, they may have been involved, but there's nothing in the record indicating that there was any indication of subrogation rights. And
what's your version of involved then, where an insurance carrier pays their client?
Well, Your Honor, that is...
And they don't pay all of it, and the client looks to the next insurance carrier. What's your legal explanation of that?
There could be a number of reasons, and none of them were provided.
And one of them would be that there's subrogation?
That's only one possibility. There could have been a
It's a
disclaimer.
possibility that Selective should have been aware of and was on constructive notice of?
With all due respect, I think there could have been a disclaimer of coverage. There could have been a reservation of rights.
But I'm not talking about those. I'm talking about the facts that have just been
Yes,
expressed here.
I do not believe so. And I think that if you look at the cases that were cited by State Farm in their brief, the Allstate versus Mazzola, these were situations where the carrier admitted knowing about the subrogation rights of the other carrier. First Fidelity admitted.
I don't need I don't need that admission to be able to determine that there was certainly enough information in front of your clients to at least require you to look into this situation. And certainly insurance companies have extra resources that the rest of the world doesn't have in finding out who's representing who and who has insurance policies for what, right?
and-
So the due diligence was on you once you had a conversation with plaintiff's daughter.
You know what? I think it was State Farm's obligation to have some due diligence. And I know that the actual notice is not an issue, but if we're looking at the Mazzola case and also the State Farm versus Garda CL case, I know it's a trial court decision, but the facts are almost identical, where the insurance specialist submitted an affidavit saying that they had no knowledge, and the court held in favor.
Counsel, the question, though, is whether you had information which, if reasonably pursued, would have given you information about the subrogation, and you had information that there was potentially another insurance carrier that provided payment.
But simply because that was there does not
That's enough.
show.
That's enough to put you on notice to do your due diligence before you cut a check that could potentially violate the subrogation rights of another insurance company.
I think it was their obligation, and Selective fulfilled its obligation fully. I don't believe that they had any more obligation than what they did to pursue any notice of another insurance company's potential rights, which they had more than enough resources to communicate to Selective, since they were both at the same inspection.
Thank you.
Okay, thank you, Your Honors.
Unless the court has any questions, I'll rest on the arguments in our brief.
Thank you.
Thank you.
Thank you both. Mackenzie Moses versus Lil Kage.
Good afternoon, Your Honors. Monica Romero for Defendants Appellants. I would like to briefly recount that the Supreme Court held that defendant appellants had met their burden under summary judgment. We believe, however, that the court also erred in holding that by introducing the report by Dr. Adeusun, plaintiff had showed that there was a remaining issue of fact. However, the report lacks any probative value. First, the report was created 5 years after the accident. And as the Court of Appeals has held, an examination by a doctor years later cannot reliably connect the symptoms with the accident.
They were also unaffirmed reports, weren't they?
Yes, that the Supreme Court correctly did not consider because they were not admissible. They were uncertified and unsworn.
Wasn't there an operative report that was submitted for a different patient?
I believe
Not
so,
even
Your
this
Honor.
patient.
I believe so. Yeah, it is on respondents' papers on a footnote that it was wrongly submitted. Additionally, the report also fails to explain how any alleged symptoms that plaintiff is telling us about is related or are related to the accident. The report does not refute or address any of the causes noted by Drs. Gruson and Weinstein in their findings. And finally, the report did not review plaintiff's medical history. And as this court has held, a plaintiff's expert must adequately address how plaintiff's current medical problems in light of her past medical history are causally related to the subject accident. Thus, the only piece of evidence that plaintiff submitted that was admissible in opposition for summary judgment really has no probative value, and it just does not establish any issues of material facts. And we believe that we should be granted summary judgment.
Thank you.
Thank you.
Good afternoon, and may it please the court. Denise Rubin, Rubin Law for plaintiff respondent, Ms. Mackenzie Moses.
So what was submitted on behalf of your client was, as you've already heard me say, was an operative report for a different patient, not this patient. There were unaffirmed reports which weren't considered. And there was a report from a doctor, but that report was 5 years after the accident. So where is the evidence that would have allowed you to meet your burden?
Respectfully, I would remind the court that the standard in opposing summary judgment is somewhat more flexible than in bringing the motion on.
Raising an issue of fact. Where is that?
The report of Dr. Edosan, I think is the pronunciation.
The unaffirmed report?
No. His signed report with his affirmation.
You mean the one that's 5 years after the accident?
But it's...
is that a yes?
Yes, but it doesn't stand in a vacuum. That report refers to all of the earlier treatment, to the surgery that was performed on this plaintiff, to her continuing complaints of pain and disability.
But there's no operative report.
No, but this doctor, who is her ongoing treating doctor, testifies to it. And again, the standard for offering opposition on summary judgment is somewhat more flexible. And this court has repeatedly held that, and the other appellate divisions have held that offering evidence that would not otherwise be admissible standing alone or at trial can be considered in opposing summary judgment.
Counsel, we don't need a contemporaneous report, but we do need a report that establishes causation. How does the doctor's report here establish causation, meaning her injuries were caused by the subject accident?
He addresses what she has said. He addresses her own history. And the question I have...
Does he address causation?
Pardon?
Does he address causation?
Yes, he says, based on the history she has given us, I do believe to a reasonable degree of medical certainty that this is caused by the accident in which she was injured.
And does he also address any of her degenerative conditions that were pre-existing?
I don't believe in that report he specifically addresses them in the sense of attempting to refute them, but he addresses, as I say, the ongoing treatment. There are also MRI reports that indicate...
Those MRI reports are unaffirmed though, right?
Yes, Judge. But again, the question is whether she has raised a material question of fact. The Supreme Court, and I believe correctly, held that she had. That, that this evidence, including the discussion of her post-surgical ongoing disability and pain. And this report that was affirmed included measurements with goniometer of the range of motion being diminished in both arms and in the lumbar and thoracic spine. And certainly that demonstrates a question of fact. The question is not, can he prove without a question of a doubt that she was injured that way in that accident? The question is, has he raised, and has the plaintiff raised, a material question of fact? And I would submit that they clearly have. And unless the court has any other question, thank you.
Your Honors, the standard for opposing summary judgment, it still requires that it be opposed through admissible evidence or for the proponent of that evidence to explain why they could not submit evidence in an admissible form. And
Counsel, so at one point, the plaintiff was undergoing physical therapy, but then there was a break in the therapeutic services that she received. How does that play into your argument with respect to whether, in fact, the opposing doctor even addressed that issue?
I don't believe it does, Your Honor, because I believe that would need to be considered if they had submitted any evidence whatsoever that could create an issue of fact, but they have not. This report really does not stand, scrutiny in determining whether or not there is an issue of fact for summary judgment because it has no probative value whatsoever, right? Like, and plaintiff did not submit a reason for not to submit that evidence as they should have. And that is the standard for summary judgment. And I know that counsel mentioned that, it's not standing alone, but it is standing alone because that's the only admissible evidence. And thus, we believe that it should be, the claim should be dismissed. Yes, it has not established causation.
Thank you.
Thank you.
Thank you both. Moore versus Wood. Just a minute, please. Okay. May I inquire?
Good afternoon, and may it please the court. Tom Backus of Lester Schwab, Katz and Dwyer for defendant appellants Roger Wood and KB Transportation. This is an appeal from the denial of my client's motion seeking summary judgment on the ground that plaintiff's decedent Kenneth Moore did not sustain a serious injury as a result of a motor vehicle accident that happened in April of 2017. Mr. Moore was 51 years old at the time of the accident. He had been diagnosed with sickle cell disease when he was approximately 20 years old and had been on Social Security disability since that time. His records from Montefiore Hospital indicate that he had end-stage renal failure and had been on kidney dialysis since January of 2015, which was...
So all of this to say he had a lot of pre-existing conditions.
Yes.
And
the lower...
So does a person who has sickle cell anemia or has chronic illnesses, are they not people who are susceptible to be injured in motor vehicle accidents? So their injuries are not compensable because they're already so chronically sick or diseased that it doesn't matter, he's gonna die anyway?
Absolutely not, Your Honor.
What were the pre-existing injuries?
The pre-existing injuries, his records indicate that he was diagnosed with osteomyelitis in December of 2016, which was about 4 months before the accident.
What is the relevance of that condition?
Osteomyelitis is an infection of the bone in the cervical spine.
What causes it?
It's an infection. It's an infection. It was related likely to his sickle cell disease, his renal stage failure. This was a man who was in very poor health.
And the osteomyelitis was in the cervical spine?
Yes, at C5, C6, and C4, C5, according to the records from Montefiore Hospital.
Is there evidence of whether or not the accident exacerbated that condition?
There's no evidence whatsoever, Your Honor. Plaintiffs...
Wouldn't you have to present evidence to show that
Yes.
it was exacerbated, or one of those pre-existing conditions was exacerbated by the accident?
The plaintiff's bill of particulars alleges compression fractures of the cervical spine, multiple disc herniations of the cervical spine, and multiple disc herniations of the lumbar spine. It also alleges a cyst of the shoulder and osteoarthritis of the bilateral knees.
The records clearly show that almost every single thing you've just listed existed on the date of the accident. We can agree on that, right? The issue is whether after the accident, was his condition worsened, right? And don't we have evidence from his daughter and from him that prior to this accident, yes, he had problems, but he went out, he was able to do things, and after the accident, that all changed.
Not at all, Judge.
Okay, so then focus on how you're saying the accident did not exacerbate these pre-existing conditions. Talk about what evidence you have that shows that
Okay.
there was no.
With regard to the cervical compression fracture, there were no complaints of pain in the neck in the emergency room, no diagnostic
And
testing
what
was
about
done in the
after
emergency.
that? Because I think the very next
Sure.
day he went and there was complaints about that, or they did studies and that was shown.
He did, there was an MRI, a CT scan because
On
he couldn't
June
get an MRI.
21st, which was a day or two afterwards.
It was about a month and a little more than
Okay,
2 months
a month.
after, Judge.
All right.
And those films, all those films were reviewed by my expert, Dr. Kim. Dr. Kim also reviewed the emergency room, the records would indicate he had the prior osteomyelitis. And based on his actual review of the films, Dr. Kim states within a reasonable degree of medical certainty that the fractures, the compression fractures are consistent with chronic discitis and osteomyelitis with anterior remodeling. Dr. Kim's review of the initial CT scan shows severe degenerative changes, cord compression, severe stenosis throughout the cervical spine from C2 all the way down to T1.
Counsel, does your doctor's affidavit, in order for you to meet your burden on summary judgment, have to address the issue of whether, in fact, those pre-existing conditions were exacerbated by the accident?
By pre-existing conditions, we can only go by what's alleged in the bill of particulars, which are compression fractures,
Yes.
cervical herniations. Then later, they try and allege the death. They try and tie the death in.
You go ahead.
Yeah.
So to answer my question,
Dr. Kim's reports firmly address the causation of the cervical findings. He reviews them from the first one that was done in June of 2017.
The question was whether he addresses whether the accident exacerbated those pre-existing conditions. That was the question. Does he address, this is not exacerbated, this is what it was?
He says these are not related. He says these conditions, these findings on the cervical MRI are not related
Does
to
he
this.
ever say the accident did not exacerbate?
He doesn't say specifically exacerbate. He says these are not related, and he points specifically to the osteomyelitis that occurred 4 months
Counsel,
before the
again, I
accident.
started by saying I acknowledge that they were there before the accident, but that's not the end of the inquiry. After you make that understanding in your head, next step in the analysis is, okay, he had these. Now, was this exacerbated after the accident? Is the question, and you keep on
The compression
not
fractures
answering
were
the
not.
question.
He says they were not related. Therefore, the corollary of that is they are not exacerbated.
I don't,
These are-
Related
Okay,
and
so explain this. He has these issues in his cervical spine before the accident. He has issues after the accident still in his cervical spine. He has surgery because of these issues in his cervical spine. So you're saying that the first issues that he had before the accident are not related. I'm not really clear on what you mean when the cervical spine issue continues all the way through. So if it was there before, then one might say, well, if he ended up having to have surgery, that sounds like something that was exacerbated because the original cervical spine issue is still the same cervical spine issue. And if it's not, how is it not? That's what I'm asking. That's what I think we have all asked. Why are you saying it is not related?
And I submit in support of my motion 15,000 pages of post-accident.
Yeah, we read it.
Right.
Why don't you tell me right now?
They do not mention the accident. They mentioned the accident once on the date of the accident when he reported it. After that, there is not one report of the accident.
So you're saying because he didn't come in and say, my neck hurts at the ER, that's not related to the accident? Is that what you're saying?
Cervical compression fractures and cervical herniations. And I also submitted the reports from his attending orthopedist at Montefiore right before the surgery. That surgeon makes reference to the osteomyelitis, that it obliterated the disc space. Also, the actual surgeon, Dr. Shaw,
Yes, I
report.
understand. So the osteomyelitis existed before, and the surgeon speaks about osteomyelitis. But does anybody say there was further compression, or there was swelling, or there was something that, sorry, I can't find it right now, but that happened to the spine? And I think that's what it was, that there was swelling or something in the spine after the accident, and then that is not related.
This is, the emergency room record on the date of the accident and the other records also indicate that Mr. Moore had avascular necrosis of the spine, which is a wasting away of the bone due to lack of blood supply. So this was an issue that was going on before the accident. That is, and Dr. Kim says that the findings of the MRIs and all the records, his treating attendant.
You mean CAT scans? I thought this gentleman couldn't
Yes,
have
I'm
an
sorry.
MRI.
The scanning. He had an MRI at the very end. Dr. Kim affirms within a reasonable degree of medical certainty that these were the progression of the prior pre-existing conditions, which again, his emergency records on the date of the accident indicate that he had severe arthritis of the spine and he had the avascular necrosis. And we
I
also
don't recall,
submit.
did Dr. Kim look at CAT scans from June 21st or thereafter and compare them to CAT scans before the accident?
Not before, not.
So then how would there be, how could one say that the condition before was not changed at all with, given this, with the CAT scan?
I would say that
after.
the unbiased people to listen to would be the attending orthopedist and the surgeon that did the surgery, and neither one of them mentioned the accident whatsoever.
Well,
They keep
counsel,
going back
this
to
is
the
a question that
osteomyelitis.
I have for you. When you say neither one of them mentioned the accident, because we are here on your motion for summary judgment on a serious injury issue, does the affidavit, does the evidence have to include some mention of the accident as it relates to causation, such that the accident did not exacerbate these pre-existing conditions?
To the extent that none of plaintiff's doctors are saying that this accident, that's highly unusual in a bodily injury case. None of these doctors from Montefiore, where he spent 132 days after the accident, from the time of the accident until his passing. He spent 132 days in Montefiore. And we also attach records indicating that he was hospitalized dozens of times in the 2 years before this accident for sickle cell disease. And if I could just bring it back.
But what about Dr. Kim, right? Dr. Kim was the one who did his examination, right?
Plaintiff had been deceased by the time, so Dr. Kim's evaluation is based on his review of the scans and the plaintiff's records from Montefiore Hospital.
And that's Dr. Kim, you rely on Dr. Kim in support of your motion, right?
Yes.
And my question is, does Dr. Kim have to, in order for you to succeed on a summary judgment claim, have any correlation between the accident and whether it exacerbated any pre-existing conditions that he saw from his extensive review of all of the records?
He affirms that there was no accident-related injury.
All right, thank you.
Did he affirm there was no accident-related injury, or that there appeared not to be any accident-related injury?
He states it within, he states that there is no compression fracture. It says it multiple times in his report that there's no, the fracture was pre-existing.
His report pretty much says that everything was pre-existing, correct? But his report doesn't say, in addition to everything being pre-existing, this accident didn't do anything to make it worse. Does this report say any of that?
I believe it does. I believe that
I
he
have
does.
it before me, so if you
It
can
says
tell me.
appears, counsel, is the language that it uses.
He does it as, what he says with regard to the fracture. Again, the fracture is the key injury that would satisfy the threshold, but there's no accident-related fracture here. And that's what Dr. Kim speaks directly to in his reports. And then, there were a couple of other categories that we could have gotten into, but unless.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court. Lisa Como for the plaintiff respondent. I'd like to point out with respect to Dr. Kim's report, it certainly is our position that he never addressed the exacerbation, and that is a really central issue in this case. When you look at the proof in the record, I believe it shows that following this accident, not only did Mr. Moore have new developing injuries at a higher level in his cervical spine, the C2, C3, which is very significant because those were a major reason why he underwent the very risky surgery that ultimately ended up with the complications that led to his demise. So
Also, his daily routines changed, did they not?
absolutely, absolutely. I think it would be unfair to completely discount the testimony.
Counsel, your reading of the case law in this department is that defendants have to submit some sort of proof regarding exacerbation in order to sustain their motion for summary judgment, right?
Yes, Your Honor, I would say so. Yes. Yeah.
Well, if you're
Yes,
not
I
sure,
think.
let us know.
No, I would say so, and I do say so, that it is certainly their burden to demonstrate and to rather refute all of the allegations in the bill of particulars. And part of those allegations are exacerbation of his admittedly, extensive pre-existing conditions, but you take your plaintiff as you find him, and that the complications from that and the surgery that was necessary to address the developing cervical issues following his decline, his rather rapid decline after this accident. Not that he was doing great before, but he was doing okay. He was going to Six Flags with his grandchild, and he was driving his vehicle on the Cross Bronx Expressway, and he was out and about. And then we see afterwards, and this is the thing I'd just like to emphasize, I know it's in my brief.
And just
Sorry.
what you said, that he was the driver of the car during the accident.
He was, yes, Your Honor, he was. And I would just like to emphasize that, and I think this is really critical with respect to the chain of events that ultimately led to his death. Dr. Kim says in his report, I think it's 752, it appears the surgery, which was the, sort of last surgery, was done to address ongoing progressive nature of his cervical myelopathy. And we're talking about the C2, C3 level principally, but he never previously had he never had myelopathy prior to the accident. There are new injuries that are documented in the scans, and Dr. Kim himself acknowledges the progression at that higher level after the accident.
Do you concede that your friend made a prima facie showing on the issue of causation?
No, I don't, Your Honor.
Okay. What was the infirmity in that prima facie showing?
Well, that he never addressed what effect on a patient like this, a traumatic injury. I mean, it was described that he hit his head on the steering wheel. He was squashed between two tractor trailers, basically. This is not insignificant, and maybe, certainly his daughter who was
Wasn't hit from behind.
no, it was like
Usual head
he was
snap.
pushed into another. He was
from the side
sandwiched, but
into another.
Like a T-bone, right?
I'm not
T-bone. He's in
sandwiched.
the middle lane, and the right lane goes across.
One comes over and pushes him, and
pushes
he's
him
in
into the
between two
left
giant
lane.
trucks. He's basically thrown about inside the vehicle. He is belted, but his head hits the steering wheel. He immediately has medical treatment. The next day, he starts an 8 or 9 month course of treatment of therapy and acupressure.
And then there's is there a period for about a year that he's not in therapy? I believe a significant.
I think it was in accidents in April of 17. I think it's like January 2018. But he had pretty much reached maximum benefit by then. It's documented, I believe, that he wasn't getting any relief. And I think at a certain point in time, there wasn't anything more that they could do for those specific things. But he's also, of course, dealing with multiple other medical issues. We don't deny that. But again, I think the burden on their part was to show that a patient like this would suffer absolutely no harm from the type of traumatic event that occurred, and where there's documented decline afterwards. I think Dr. Kim or whoever had to come and say, no, that would have happened anyway, just due to his sickle.
The fact that he was treated right afterwards, and then he did get therapy, and like many people, he was given the therapy, and then it reached maximum benefit. What does that mean?
But he had a new injury at his upper level of his C2, which continued to get worse. And one thing that they did not address was, I think there certainly have to be special circumstances and considerations with someone in this state of health and the effect of the trauma. I don't think they could say that it would have done that would have happened anyway. regardless, I think it was like a chain of events was set in motion by the accident, and they did not demonstrate that that did not cause this.
Thank you. There's a
I have a question.
Yes, Your Honor.
I believe that the record shows that there was a CT scan prior to this accident that showed that he had compression fractures in the cervical spine at certain levels.
Yes, Your Honor.
Is there anywhere in the record where there is a comparison of those two CT scans to show the difference pre-accident, post-accident, in terms of disc desiccation, loss of height between the vertebral bodies, anything like that?
I don't believe they showed that, Your Honor, and the prior stuff was all at like C4, C5, and then afterward, it was.
So that the prior CT did not have a compression fracture at C2, C3?
I don't think there was ever a compression fracture at C2. That ended up being the worst herniation. He had bulges below, but that ended up being the worst herniation, so I think they had to show that.
But according to the post-CT scan, there was a compression at C2, C3 requiring the pin, which is why he had the surgery.
Yes, eventually, but there wasn't before.
And one last question. After the prior CT scan, when the initial compression fractures were discovered, was there a plan for him to have the surgery he ended up having post-accident?
No, not at all. There's no evidence whatsoever that he would have needed that unless this had happened, and I think that was their burden to show.
Thank you.
Thank you very much for your time.
So counsel, you conceded in your prior argument that Dr. Kim did not review and analyze and assess the difference between that prior CT scan and the post-accident CT scan. How can this court give any weight to any opinion by your expert about exacerbation where he did not even bother to review the CT scan in order to do an analysis and comparison?
Judge, I think that the best evidence is plaintiff's own. You could take Dr. Kim, you know.
Counsel, answer my question.
Sure.
Okay,
How can
I
you
know
put
the
Dr. Kim?
arguments, I get it. I've asked you a very specific question. How am I supposed to give credence to your expert's opinion about the lack of aggravation when his assessment did not review the key piece of medical evidence, the prior CT scan, which would have shown a difference between the seriousness of the compression fractures, if there was a worsening of the compression fracture, if there were new compression fractures, which, based on my review of the record, seemed to indicate there were additional new ones. And if that's so, then that certainly satisfies 3101D.
Plaintiff's bill of particulars, which is what we have to be bound by, alleges fractures at C5 and C6, and those are the exact fractures that Dr. Kim addresses in his report. Plaintiff was on dialysis since 2015. His own treating physicians from Montefiore, the reports clearly indicate this was degenerative. Basically, his own spinal surgeon says he had poor bone stock.
Counsel, we've gone through this before. I got it. I have not at all in any way contradicted that. But you seem to think that the analysis ends with that, and that's where you and I part.
I don't agree with that characterization of my argument, Judge, but I appreciate your questions. Thank you.
Anything more?
Well, just with regard to Dr. Sarabona, it's my position that our papers establish prima facie entitled summary judgment based on the injuries alleged in the bill of particulars. Plaintiff's expert relies entirely on unaffirmed reports that are not admissible. The only film that he actually reviewed, Dr. Sarabona, was the first one done in June of 2017. And if I could just, with regard to Mr. Moore, he did appear for a deposition in December of 2018. I took the deposition. We got a couple of hours in, and Mr. Moore basically called the break, and then he left the deposition and was suspended at that time before we could really question Mr. Moore about his injury history, about his damage, about what his daily customary activities would be. And his decision to leave the deposition deprived us of the opportunity.
His decision because he was feeling sick and tired because he has sickle cell.
Judge, I believe that's speculation. I was there. I don't think that's why he left.
Well, I don't know that you made any arguments saying that you would have him come back or challenge the fact that he left.
It was. We put a statement on the record at the end. Plaintiff's counsel agreed to reproduce him, but unfortunately, he passed away in the interim.
Thank you.
Thank you.
Thank you both. People versus John Appouzi.
Center for Appellate Litigation by Molly Booth. Mr. Appouzi asks this court to consider a sentence of 10 years, which would reflect both the very serious nature of the crime to which he pled guilty and also the role of addiction that the role of addiction in that crime.
Well, Mr. Appouzi had a very difficult childhood. I agree. It was absolutely awful. Caused PTSD. He was faced with the stress of cancer after being out and doing well for several years. But does all of that justify a 5-year reduction where this plea was so carefully negotiated with the victims in the new crimes he committed, which were heinous? I mean, they were just absolutely awful. But the fact that they were so carefully negotiated with the victims, does this justify a 5-year reduction now?
I believe that the interests of justice is better served by a 5-year reduction now. I first want to address, I'm only asking for a reduction on the sentencing of the kidnapping. I'm not touching, first of all, there was no plea related to one of the robberies, but I'm not asking this court to touch the other robbery sentence, which was 7 years and is concurrent. It's just the 15-year sentence he received for the kidnapping in the 2nd degree.
That's why you're not asking, because automatically by operation of law, by reducing on the one you are asking,
sure, but I'm not coming here
takes the
asking,
ride with the other one.
Sure, but if I were asking for 5 years, it would to say that the sentence for the 7 years was unjust, and that's not what my argument is. My argument is 10 years is just, and that is far above the minimum I could be asking for.
How do we gauge what is just?
So I think in this case, you have somebody who was able to live a law-abiding life without the support of drug treatment for 15 years, and who has a specific PTSD that is related to an act of violence that happened to him when he was a minor, incarcerated before his 15 years of success.
Counsel, aren't we foreclosed from looking at this excessive sentence issued by the valid waiver of right to appeal?
I expected that question, and so
Glad you did.
I want to draw this court's attention to a couple of aspects of that waiver of appeal. First, not only did he allocute as to the facts before he entered into the waiver, the prosecution asked a follow-up question about what those facts were. So at this point, from Mr. Appouzi's perspective, the horse had left the barn. And I'm not just relying on that, though.
Well, why don't we just slow down on that, right? Let's talk about that before we move to the other things you're relying on. In this department, that does not invalidate a waiver, right? The fact that the factual allocution was done before the waiver of right to appeal allocution, right?
It certainly cannot be the only thing.
Okay.
Which is why I want to mention that before he entered into this plea, he was actually set to take a plea, and defense counsel ordered a 730 based on the exacerbation of his PTSD symptoms, which get worse in times of stress, and honestly, taking a plea of 15 years is an incredibly stressful time. And so those 730 reports do reflect his severe mental illness. He's certainly fit. I'm not arguing he's not fit, but I'm also saying that the person who is trying to walk their way through this very difficult appeal and revisit the factual predicate of that appeal when they're engaging with the court on the waiver of appeal, having already admitted to the crime, is going to play into the voluntariness, the intelligence, and the knowingness of that waiver. He also had not entered into any kind of plea or been in any kind of colloquy with the court about a plea in over 20 years at that point. And so it's not like his prior experience would have been really brought to bear when he was allocated on that waiver of appeal.
Did you? Okay.
May it please the court, Kevin Peterson for the Law Office of Darcel D. Clark. Prior to his plea, defendant, in consultation with counsel, engaged in extensive negotiations to get a lenient sentence and sent the people a PPI detailing difficult life circumstances.
And the court and the people gave significant consideration to all those persuasive mitigating factors, correct?
Correct, Your Honor. The people had first offered 18 years of incarceration for his aggregate sentence for 3 different heinous violent crimes with 3 different victims. And he sent this PPI that is the same information that is now being argued for an additional reduction, and the people came down to 15 years and explicitly stated on the record of the plea hearing that these specific facts are what motivated them to lower that sentence by 3 years.
Regarding the waiver of right to appeal, if we deem it to be valid, we're foreclosed from looking at this excessive sentence issue, correct?
Correct, Your Honor. And this appeal waiver,
I was going to let you tell me that it's valid.
I believe all the hallmarks of a robust appeal waiver are present here. We have,
Except the fact that it usually takes place before the person pleads guilty so that they understand specifically all of the rights that they're waiving by pleading guilty.
correct, Your Honor. That is not ideal how it happened, but
But it followed the model colloquy, right?
it did follow the model colloquy. Defendant in advance had discussed the appeal waiver multiple times with counsel, including after the 730 exam, and you can see both counsel and defendant repeatedly state that they had discussed the appeal waiver, including the written appeal waivers, and I believe that it was at page 9, page 6, and page 16 of the plea hearing minutes where you can see these on-the-record affirmations of discussing the appeal waivers. Additionally, he affirmed his understanding of the court's colloquy, which followed the model colloquy. And he signed not 1, but 2 written waivers of appeal. So
Those all happened after he pled guilty?
I believe so, Your Honor. But based on the totality of circumstances, we still think this is an experienced defendant. There was this extensive negotiation.
Experience. I have experienced lawyers who don't get it right. What does that mean exactly, experienced?
Your Honor, he had 2 previous guilty pleas, and one had happened, I believe, 15 years previous.
That's not exactly experienced.
Correct, Your Honor.
In my limited experience, no 2 people do these waivers the same way. So I don't know, it's kind of like getting a study guide off someone. It may not be the best document to use to prepare for the test. So maybe he used a plea waiver in a prior plea, and that was no model of clarity. So I don't know how important experience, whether remote or recent, is.
I acknowledge that, Your Honor. I do believe that
In any event, you feel that the plea and all of the things considered in reaching that plea was a fair plea, and you don't believe that we should reduce.
Indeed, Your Honor.
Thank you.
Thank you.
I just want to add that I do believe the last plea he took was in 1997, and it is hard, as Your Honors have observed, it is hard sometimes for lawyers and for judges to get these colloquies exactly right. And coming from the experience of standing next to somebody who is entering into this kind of weighty
But
plea.
this wasn't a spur-of-the-moment plea, right?
No.
This is a plea that had been discussed and negotiated. In fact, I'm sure your office put together a very weighty memorandum for the judge and for the DA's office in order to arrive at this plea, right?
That's right.
And I would imagine in order to do that, there were discussions going on with your client throughout that entire process in order to get all of the information you needed for that that report, right?
Yes.
And I'm sure because your institution, this is what they do, they counsel their clients and inform them of what they're doing.
Of course, and it was Bronx Defenders. It wasn't my office, but I will say that when you're talking to somebody who's taking 15 years, who has a history of violence while incarceration as a teen, the primary subject of that conversation, almost to the exclusion of being able to hear anything else, is going to be that 15-year sentence. It's like telling somebody they have cancer and then wondering if they signed the waiver form for the office, the way it operates in these conversations. And so I just want to offer that to the court as something that I believe is relevant to the appeal waiver.
Thank you. Thank you both. Okay, at this time, Justice Marcia Michael is recused, and we will hear number 2, which is Anderson Avenue versus Fuller. Oh, yeah, good. Yeah.
Good afternoon, Your Honor. May it please the court, Zoe Kamen of the Legal Aid Society for Doreen Fuller. Your Honor, every litigant should be given the opportunity to have a fair trial, a trial on the merits. It is our contention here that Ms. Fuller did not receive a fair trial under the substantial justice standards set forth in the Woodson case because she was not able to enter legal defenses, defenses that are apparent on the record, defenses that are potentially meritorious.
She didn't have an attorney.
She didn't have an attorney, that is right.
Guardian ad litem did not help her in any way.
No, Your Honor. You can see on the transcript that their relationship is breaking down in real time.
There's no answer filed.
There is a general denial entered on her behalf at trial, correct?
And her guardian ad litem basically testified against her.
That's right. Adverse testimony was entered
Not
against her at
assist her in
trial.
cross-examining the witness, correct?
No, Your Honor.
And didn't help her submit any kind of evidence.
No, Your Honor.
So even if we get over this hurdle of vacating the judgment and the warrant of eviction, on what basis would the HSPTA be retroactive?
Your Honor, of course, we don't necessarily concede that it is retroactive. There is a reading of the HSTPA that could make it prospective. The statute applies in situations where
How do you
an
get
apartment
to
is
the
rented.
retroactivity of it? Usually, there has to be in a statute, I mean, there are the 4 factors, and it has to be a clear expression of legislative purpose to justify the retroactivity. Is that reached here?
We believe
Are all of the 4 factors reached here?
We believe so, Your Honor, because the statute doesn't just go into effect immediately. It goes into effect immediately in a very narrow, very specific circumstance, and that is in situations where an apartment is being actively rented to a supportive housing provider and there's an affiliated subtenant. This meets the criteria set forth in the statute in such a way that the application could be considered prospective. If the court is not persuaded that this is a prospective application, we submit to the court this is not an impermissible retroactive application of Part H, because of the HSTPA Part J, because the standards set forth in the Regina Metro case, in the Harris decision, and most recently in the Aaron Manor case and the accompanying Chu test, all of these tests demonstrate that cases need to be retroactive cases need to be evaluated on a case-by-case basis. And
All the more reason why your client should have her day in court with counsel to assert her defenses.
absolutely, Your Honor, the decision in this case is bereft of any kind of fact, of any law, of any analysis. There's not even a recitation of the facts. And so in this specific case, now that Ms. Fuller has the benefit of counsel, she should be permitted. It's a very narrow thing that we are asking for. It's just the ability to enter an answer containing these potentially meritorious defenses.
Even if we granted that, I mean, it sounds like it's not certain that the HSPTA would be considered retroactive. How does 2520, Section 2520 F and K apply to you of the rent stabilization law?
Sure. The court doesn't really reach these conclusions, but it's important here to note that Section F of the rents of 252011F doesn't apply here at all because it is specifically for buildings that are operated exclusively for charitable purposes. There's no question that this
building
doesn't
is
apply.
not here.
Exactly. This is a privately owned building by a large corporation. And so this is not, Part F doesn't apply here at all. The court failed to even examine this cause of action. And the second cause of action requires a mandatory predicate notice. These are predicate notices. These are guardrails for the proceeding to ensure the integrity of the proceeding. The Golub notice would have actually informed the court that this is a rent-stabilized apartment. Not only does the petition specifically state, erroneously, falsely state that this apartment is not subject to rent stabilization, but twice at trial, respondent appellee's counsel actually tells the judge, Your Honor, this is not subject to rent stabilization twice. And so without the Golub notice, this is a tenant with diminished capacity. This is a guardian ad litem who is not assisting with obtaining counsel. And so this is an opportunity for Ms. Fuller to have the judgment vacated to raise these defenses. These are potentially meritorious defenses, and we draw parallels to the Rochdale case where the tenant was permitted to raise jurisdictional defenses because they had a colorable claim to the apartment. The court doesn't necessarily here need to find that HSTPA is some sort of vested succession right to the apartment, just a colorable claim to the apartment in order for Ms. Fuller to be able to assert these jurisdictional defenses, such as the Golub notice, and that part 2025-11F does not apply. And these are defenses that are apparent from the record. We're not raising any new issues of fact. If the court took a look at the papers, the court could have also made this determination after trial, during trial. Of course, the court was impeded in this case under perhaps the mistaken belief that this apartment wasn't subject to rent stabilization. And so the fact that the service provider waived these claims should not mean that Doreen Fuller, a vulnerable tenant who has 10 years of street homelessness, who has now finally found stability in her life, she should not now be forced to waive these potentially meritorious defenses to a rent stabilized apartment.
Thank you.
Good afternoon, Your Honors. David Troop for Anderson Avenue Associates, LP.
So how did this tenant have a fair trial here when throughout she's saying, oh, I'll take care of that at trial? She doesn't realize that she's in a trial. She has no attorney. No one contacted the Legal Aid Society. It's all been said before. She's has no representation there. The guardian ad litem is not representing her and testifies negatively about her. How is that a full and fair opportunity to be heard? How did she receive that?
Obviously, it's a difficult question to say what's a full and fair trial when somebody is not mentally incapacitated.
Well, how about when they say, I'll take care of that at trial? Well, and you're saying, but this is the trial.
Or when she says, I don't know what's going on.
So
perhaps I'll make this easier for you.
Yes.
Instead of, if I may, full opportunity, robust opportunity, how about simply a fair proceeding? What confidence should we have when we look at that modest transcript that this litigant had just a fair proceeding?
Well, I think that the presiding judge did her best to explain what was happening, and I would also note that in housing court, proceedings are recorded, but sometimes there will be conference before the trial begins.
What difference did that make here, if it happened at all? And it doesn't sound like it did. I don't think you're going out of the record to talk about something you don't know whether it happened or not.
I understand, Your Honor.
Sometimes it's okay to just say, I rely on my papers.
Understood, Your Honor.
We don't all get easy cases, we get that, okay? We've been on that side too.
Thank you, Your Honor. I appreciate that. If I may, even if Your Honors decide that she was not afforded a fair trial, the HSTPA section, by the weight of the cases that we have seen since the HSTA was passed, the language used in this part of the HSTPA has repeatedly been found that it's not enough without more to apply it to a pending proceeding. So the language used is, this act shall take effect immediately, but there is substantial case law from the Court of Appeals saying that that phrase by itself means that we're dealing only with prospective application rather than applying it retroactively or to pending proceedings. And regarding...
In the statute, there are sections that say it does not apply to anything that is already pending, and then other sections that say it does apply to actions that are pending that have not reached the final judgment, right? Different sections get applied differently. This particular section is kind of silent. So why should we read one way or the other in light of the fact that it is silent on that?
Right, and I think that the answer is that the Court of Appeals has said only that more is required. So the burden, so the comparison is not with sections with effective date language that go further, but with sections that, excuse me, I think I said that the other way. It's not the negative, it's the positive, that you have to add. It's not the absence that matters, it's the additional language making clear that it's intended to be applied retroactively.
Would we be the first appellate court to address the retroactivity of Part J?
Yes.
Okay. So normally, the law develops best when a matter is litigated before a trial court, right? Flushed out. The trial judge gives the appellate court the benefit of his or her view on the issue, particularly in a specialty court with a subject matter like housing law. Then we'd have the additional benefit of appellate term, which has a specialty in landlord-tenant law. And then the issue could come to us. Why should we address this issue on our own for the first time now on this appeal?
Although not on the record, there was a motion to re-argue where it was raised. So it actually was already before the lower court, and they declined to grant re-argument.
So then it wasn't addressed substantively.
I'm sorry. Please forgive the phrasing. The motion was addressed, but the motion to re-argue was denied. And if I may also, just on the predicate notice issue, the only way that the appellant would have standing to challenge that notice is with an independent possessory right. And there is no independent possessory right if the HSTPA, if Part J of the HSTPA does not apply here. So I'm respectfully submitting that Part J of the HSTPA does not apply, and that...
And so it doesn't matter whether she got a fair trial or not?
Well...
Is that what you're saying? I'm asking.
It doesn't matter.
You believe you're going to be, you believe on the merits you're victorious. I get that, I respect that. But that doesn't change the fact that this woman was completely deprived of a fair trial. And we normally don't sanction and rubber stamp that.
Understood, Your Honors, and then I suppose all that I can ask standing here is if the court makes such a finding, then I would ask that to the extent possible, the lower courts be given guidance, because a decision that just says that
You want us to tell them what to do and how to decide? That's not what we do.
I think the key is really about giving a litigant the opportunity to be heard properly in the first place. When a person has no lawyer, when there has been no answer filed on behalf of that person, when the person appears with a guardian ad litem that testifies against them, I think there's some reason to believe perhaps that person has not gotten the opportunity to be heard.
Understood. Thank you, Your Honor.
Thank you.
Your Honors, may I just please very briefly address some of the things that my opposing counsel here has touched upon. The first being that it's not clear whether or not the legislature intended for Part J to apply here. It's true, some parts of the HSTPA apply to pending proceedings. That is explicit. There are other parts of the HSTPA, including a section in Part J itself that specifically excludes pending proceedings. It says that this will apply at the renewal of the lease term. Part M applies in 30 days, in 120 days. And so there's certainly a lot of ambiguity, and in times of ambiguity, the court looks to two things. The first is the plain language of the statute itself, which says that it applies immediately in situations where there's a tenant who is renting an apartment and they are affiliated with a program, which is exactly what is going on here. And the second thing is the legislative history. Of course, we don't have a lot of that here, but the legislative preamble is interesting insofar as it describes this exact situation. This situation is something, unfortunately, that we see in housing court quite often, where a supportive housing provider vacates an apartment, leaving a formerly homeless tenant, a vulnerable tenant with all kinds of mental health issues, addiction issues. An elderly tenant leaves them high and dry in an apartment subject to eviction. And so what the legislative preamble says here is that Part J was created to ensure that units rented by nonprofits to provide housing to homeless people revert to rent regulation at the end of the use of the nonprofit, and that previously homeless person or persons are treated for tenants of purposes of the law. This means that the legislature specifically envisioned this situation, and this is the exact situation we have here. And so if there's a question of whether or not the legislature intended for this to apply to pending proceedings, this is it. It's right here. In Regina Metro, and in the cases where retroactivity was disallowed, the court actually creates or actually asks a question of whether or not this is such a destabilizing effect. Can this really be what the legislature intended? And the answer here is absolutely. There is no destabilizing effect. This is an apartment. The rent hasn't changed. The rent is not going to change. Next tenant, the tenant after, they're going to be paying exactly what Ms. Fuller is paying. There's no punitive financial impact. And in this situation, we submit to the court that Anderson Avenue Associates has failed to demonstrate improper retroactive effect here.
Thank you. Thank you both. Okay, the next case is Oachcher versus Clark. And I'm recused from that case, so Justice Manzanet will control the clock, and Justice Michaels will be back in a moment.
Counsel, you may approach you may proceed.
Good afternoon. May it please the court. My name is Adam Oachcher, and I am the petitioner appellant with regards to these appeals, which involve FOIL-related Article 78 proceedings. Just as a point of order, to my understanding, the fee-related appeal is non-enumerated. I'm prepared to argue it. I know it was addressed briefly during the calendar call. I was going to focus most of my argument on the two FOIL-related proceedings because they are enumerated. So these appeals arise from a meeting I had with two of respondents' employees in August of 2019 to assist respondents in responding to a CPL 440 motion in the case of People v. Tracy Clark. I am a former Bronx County Assistant District Attorney, and I volunteered to assist respondents in defending this motion. That motion involved a case I tried in which the defendant was convicted of murder in the second degree and attempted murder for murdering someone and shooting someone in the neck. During this meeting, the two assistant district attorneys handling the motion admitted that they could not locate large portions of their case file. Later in the meeting, the two ADAs revealed that the district attorney's office destroyed the computer on which much of the evidence and the case records in the Clark case had been stored. As a point of fact, the computers and servers that the DA's office destroyed didn't just have the Clark record stored on them. These computers had thousands upon thousands of records and pieces of evidence and thousands upon thousands of cases stored on them. And when I say evidence, I'm talking DNA reports, witness statements, crime scene photographs, lineup photographs, search warrants, wiretaps, the entire gamut of criminal evidence in innumerable cases. As an aside, to the extent that respondents dismiss it as an allegation, as they've attempted to do in the past, this meeting was recorded with the knowledge and consent of ADAs Lewis and White. Following the meeting, I reached out to respondents to see how they were addressing their destruction of case records and evidence. I wanted to ensure that the DA's office was taking the necessary and proper steps to fully investigate the destruction of case records and evidence and notify the courts and affected parties. The two ADAs, Lewis and White, stopped responding to my emails. I would note that this wasn't a de minimis mistake. Pursuant to New York County Law, Section 707, and the New York City Charter, the respondents are required to preserve these records. And those two ADAs inadvertently revealed that the DA's office violated the law, not just in one case, but in thousands of cases. At this point, the respondent's Deputy General Counsel jumped in and instructed me that the DA's office would no longer speak to me on this issue. Instead, she instructed me to submit FOIL requests. I was thus put in the position of being a whistleblower, and I did what she instructed, which is how I find myself here. In response to FOIL requests that are not the subject of this appeal, respondents admitted destroying case records and evidence in 5 cases involving homicide convictions without notifying the courts or the necessary parties. The FOIL requests are the subject of the Article 78 proceeding before Judge Guzman address emails sent to and from my email account when I worked for the DA's office with regards to those 5 homicide convictions. While respondents conducted an initial search and provided me with some responsive emails, I provided respondents with a copy of an email that respondents should have provided me but didn't. This email was of unique import in the Clark case, as it was mentioned in the trial transcript. It was a critical exhibit in Mr. Clark's initial 440 motion. Of equal import was respondents' failure to produce this email in response to my FOIL requests, because if they couldn't produce this email, this means not only that respondents did not preserve case records and evidence, but respondents failed to preserve emails as well, which the DA's office is also legally obligated to do. After their initial production of emails to me in response to my FOIL requests, I gave respondents every chance to conduct further searches and produce a certificate of diligent search that would complete these FOIL requests. But respondents, recognizing that providing that certificate of diligent search would constitute a further admission that they failed to preserve a critical piece of evidence, refused to do so for years, resulting in 35 statutory violations. It was only after I commenced the Article 78 proceeding before Judge Guzman that respondents provided the certificate of diligent search, thereby completing their responses to these 5 FOIL requests. Which brings us to the issue at hand. Having compelled respondents to provide a...
You can finish your thought.
I appreciate, Judge. Having compelled respondents to provide a complete FOIL response by commencing an Article 78 proceeding, as a matter of law, I substantially prevailed and am entitled to an attorney fee and costs award. And when I say that, as a matter of law, I'm relying on this court's decisional authority in Jaskarin and Dioso Fastino, each of which holds that when an agency provides a complete FOIL response after the petitioner commences an Article 78 proceeding, that constitutes substantially prevailing, requiring an attorney fee and cost award pursuant to PBO 89-4C.
Thank you.
Thank you, Judge.
You may proceed.
Thank you, Your Honor. Good afternoon, David Cohn for respondents. So I'm not going to engage in the unsupported allegations of misconduct that pervade petitioner's filings, both his FOIL requests and his brief to this court. He's accused every ADA involved in this litigation of misconduct, including myself. He's accused the judge below in the attorney's fees case of misconduct, claiming over and over the judge didn't even read his papers when the judge said on the record
Yes,
that
I
he
saw
did.
that repeatedly.
Yes, and so, Your Honor, I'm going to turn to the issues before us. So first, there's Justice Tewitt's ruling about res judicata, which Justice Tewitt said was the reason to dismiss petition number 4. That was an appropriate ruling. The Court of Appeals has held res judicata is intended to ensure finality, prevent vexatious litigation, and promote judicial economy. Also, once a claim is brought to a final conclusion, all other claims arising out of the same transaction or series of transactions are barred based on res judicata. And this court has recognized that a court has the ability to dismiss a civil complaint sua sponte in order to perform efficiently its judicial functions, protect its dignity, independence, and integrity, and make its lawful actions effective. That's from case law cited in our briefs. Now, here, petition number 4 arose from the same records access order determination that was the basis for petitioner's previous petition number 3. It included.
Was there ever an attempt or a request to consolidate those petitions so as to not waste the scarce judicial resources of this court?
No, there was no such attempt, and that's one of the reasons why Justice.
Was there ever an attempt to amend a petition and include more allegations?
No, there was not. And Justice Tewitt noted both of those factors in invoking res judicata in this case. And again, I will not go into all the history that's in the briefs, but vexatious litigation is another reason the Court of Appeals has recognized as to why res judicata may be applied, and this is a perfect example of that situation. And so even though it was not raised as a defense by respondents, and we acknowledge that, Justice Tewitt appropriately under the law applied res judicata under Court of Appeals precedent. And as Your Honors have noted, petition number 3 was pending at the time the petition number 4 was filed. In fact, respondents hadn't even answered that petition yet. Their response was due about a week after petition number 4 was filed. Petition number 2 actually was still pending at the time. And so petitioner could have pursued this litigation in a less haphazard fashion and didn't. And that's why res judicata was properly applied. Also, as we explained in our brief, even if this court does not affirm the res judicata finding in a civil appeal, this court may affirm on alternate grounds. And the records access officer's determination is thorough, it's detailed, it provides specific detailed reasons. A lot of the requests were not denied outright. Petitioner was asked to narrow some of the very broad-ranging requests and refused to do so. Also, some of the requests.
Your adversary argued that he was entitled to attorney's fees because he substantially prevailed on his FOIL request.
On the certificate
Is that the case? And if not, why not?
That is not the case, Your Honor. And so that's about petition 2. So in petition 2, petitioner does not contest any of the substantive rulings by Justice Guzman in denying petition 2. What he's arguing is that a certificate of diligence search, a CDS, was not timely given to him. Now, the timeline of this is important. In response to petitioner's administrative appeal, and I believe the date is on October 1st, 2021, the FOIL appeals officer, respondent's FOIL's appeals officer, directs the records access officer to issue that CDS within 60 days. Now, the records access officer previously explained because of the changeover in the email system from an internal email system to being run by the city, there was extra time that took for that to happen. The appeals officer. Because
the officer in the BDA office doesn't have access to search in the DOITT
Exactly, the DOIT, what the city calls DOIT, right? The DOITT office is independent, and all the email searches have to go through them. In fact, every email address at the Bronx DA's office is a New York City email address. And so the appeals officer orders that this CDS be filed within 60 days. 3 weeks after that, petitioner files an Article 78 petition alleging that there was no CDS. 60 days after the appeals officer issues that order, the CDS is provided. So the appeals officer's order was filed. The CDS was provided in the time that it was going to be provided. Petitioner cannot manufacture an attorney's fees claim just by filing an Article 78 petition in the interim during the 60-day period while the records access officer is preparing that CDS. That is abusive litigation. That should not be rewarded with attorney's fees. As to our other appeal, where we have a cross appeal, I'll address that in my rebuttal time.
Okay. Counsel?
Briefly, in reply, you know, they base their opposition to the fee award in the Judge Guzman case on the remand of their FOIL records appeal officer. That was a FOIL violation, right? In response to, according to PBO 89 subsection 4, a FOIL appeal officer is given two options in rendering a determination on an administrative appeal. They must either fully explain their reason for the denial or grant access to the document. They cannot remand. And that's not me saying that, right? Because what happened is the attorney in another Article 78 case in which the respondents violated FOIL against the journalist George Joseph, that lawyer wrote a letter to the Committee on Open Government. And the Committee on Open Government rendered a decision, sent the letter right to the Bronx DA's office. This is addressed in the briefs, in the motions. And they told the Bronx DA's office that their FOIL records appeal officer's practice of remanding matters, and this is how they're defending this fee award right now, violates FOIL. So they are trying to use a FOIL violation to argue that the attorney fee award should not go forward. And just with regards to res judicata, this court has a body of case law. Just you were on the Andrade case, right? You have Andrade, you have Macy, you have Cobb. This court holds that res judicata applies in a FOIL case when a subsequent Article 78 proceeding seeks the same documents that were sought in the first Article 78 proceeding. Now, in Cobb, the court
It also says that if in your first petition, you should have included requests for X, Y, and Z, and you didn't, you don't get a second bite of the apple and get to file another petition.
But I couldn't.
Okay?
But I could not. And on that point, I referenced this court's recent FOIL decision in Cuomo versus James, right? In Cuomo versus James, a former governor's FOIL appeal was dismissed because he brought an Article 78 petition before he had exhausted all his remedies. You were on that case as well, right? So you had this weird interplay with Article 78 where you have to bring it within 4 months of the denial, but you can't bring it until you've exhausted the remedies. So I had to wait to exhaust the remedies, exhaust relief in the FOIL appeal, in the Article 78, before Judge Tuitt.
Counsel, there was nothing at all that prevented you from amending your petition. Nothing.
The only thing that I agree. What I had to do was I had to make a motion.
You made a choice, and you will live with that choice whichever way this goes. You will have to, counsel?
Can I just finish with one thought?
No, there's no question before you. We have no more time. According to my argument sheet, you have no additional time. We are done. Thank you, gentlemen. Have a good day.